Members of the LIBE Committee, thank you for the invitation to testify before you today, and thank you for seeking out the advice of technical experts. In my testimony before you today, I will make two main points. First, the mobile phone networks in Europe are not safe. They're not safe from American intelligence agencies, from the Russians, the Chinese, and other governments too. Second, that European policymakers and regulators have had ample warning about serious security flaws that expose European citizens' communications to interception. Sadly, these warnings have often been ignored, or worse, instead of fixing the flaws, they have been exploited by European law enforcement and intelligence agencies. In October of this year, the topic of mobile phone privacy instantly became an issue of significant political concern after journalists writing for Der Spiegel revealed that the U.S. National Security Agency had for years monitored the telephone calls of German Chancellor Angela Merkel. Subsequent reporting also revealed that the phone spying was conducted by a joint NSA-CIA unit which operates out of 80 U.S. embassies and consulates around the world. Ordinarily, it should not matter that mobile phone signals can be intercepted as they pass through the air. The security of the mobile telephone network should not depend upon the difficulty of recording the signals, but rather there should be other security technologies in use that protect our calls. For example, we all regularly use open Wi-Fi networks at coffee shops and hotels to conduct sensitive tasks, such as sending emails and doing online banking. Although these Wi-Fi networks are not secure, the internet services we use over the Wi-Fi networks are themselves secure. For example, the lock icon that you see in your web browser when you connect to your bank's website, to Google, or to Facebook is an indication that your interactions with those sites are secure, even if the Wi-Fi network you are using is not. Sadly, there is no lock icon built into our mobile phones. The security that is built into mobile networks is decades old, very weak, and in fact, quite thoroughly broken. As such, there is little protecting our calls, your calls, from the NSA or in fact any other government. The security vulnerabilities in GSM mobile telephone networks exploited by the NSA have been known in Europe for nearly 2 decades. For example, Rohde & Schwarz, a German company, is generally believed in 1997 to have created the first commercial device capable of intercepting mobile telephone calls. Several other European companies, including firms in Germany, Switzerland, and the United Kingdom, manufacture and sell similar surveillance products that are capable of exploiting long-standing security flaws in mobile telephone networks to intercept calls and monitor nearby phones. The customers of these European surveillance companies include law enforcement and intelligence agencies in several European countries. Although this technology is generally introduced and used in secret, in Germany it has been used and regulated in a relatively transparent manner. For example, German law regulates the use of this technology by government agencies. It requires statistical reports to be published every year. Moreover, it has been the subject of several formal parliamentary questions, as well as a decision from the German Constitutional Court permitting its use. This, of course, means that your own law enforcement and intelligence agencies have known that telephone networks in your respective countries can be spied on by anyone with the right equipment. They know this because they have purchased and are using this equipment for surveillance. Furthermore, as European companies are manufacturing and then exporting this technology outside of your own borders, it is likely that other government agencies, such as national telecommunications regulators and export permit granting agencies, also know about the long-standing telephone network security flaws and the technologies that can exploit them. Now, it would be one thing if this technology were only manufactured by European companies and sold to European governments. However, that is not the case. Companies in the United States, in China, Russia, India, and Israel sell similar telephone spying technology to their own governments and to other governments around the world as part of the $5 billion global market for commercial surveillance technology. Mobile telephone interception devices are reportedly among the, quote, best-selling items exhibited at surveillance industry trade shows. Indeed, a few weeks after it was revealed that the United States was spying on the telephone calls of Chancellor Merkel, media reports revealed that China, Russia, the United Kingdom, and even North Korea were also intercepting her calls too. Even if the American government keeps its promise to stop spying on the calls of Chancellor Merkel, no amount of political pressure will stop these and other governments from using their spying equipment too. If telephone calls can be intercepted, they will be intercepted by those governments capable of doing so. What this means is that if you do not wish for your calls to be intercepted, you must do something about it. During the past few years, prominent security researchers have repeatedly warned about the flaws in mobile telephone networks that these so-called government-grade surveillance devices exploit. Although interception once required a $50,000 device, commercial surveillance device, to intercept calls, it is now possible for researchers, hobbyists, and hackers to build their own interception devices for a few $100s. For example, in 2010, a security researcher intercepted calls from the phones of audience members at the DEF CON security conference in Las Vegas. Mobile telephone interception technology has been democratized. In spite of the repeated warnings by researchers, telecommunications regulators in Europe and in my own country, the United States, have ignored the security problems. Likewise, the major telephone service providers have neither been forced to improve the security of their networks nor warn their customers about the significant risks of interception. As you continue your inquiry, I strongly encourage you to look into the widespread failure of European telecommunications regulators to protect your telephone networks against the threat of interception by governments using technologies that are now widely available. It should not have taken the leaks by Edward Snowden to get policymakers to start thinking about the security of your telephone networks. If you do not wish for Americans, the Russians, the Chinese, or any foreign government to spy on the phone calls of your policymakers, business leaders, and journalists, you must take action. However, protecting your telephone networks from such surveillance threats will also require the large-scale deployment of advanced encryption technologies that will thwart your own law enforcement and intelligence agencies' use of the same interception technology. There are systems that are secure against all threats or systems that are secure against no threats, and right now you have systems that are secure against nothing. Your senior political leaders likely already have government-issued encrypted telephones, although I suspect few, if any, members of this committee have them. These devices are usually quite expensive, although communication security does not have to be a luxury. In fact, freely available open-source encrypted voice communication software apps already exist today, which anyone can download and use. The real question is whether you are ready to promote, or better, to provide all of your citizens with the same degree of communications confidentiality and thus protection from wiretapping by governments foreign and domestic that your own political leaders already enjoy. I strongly urge you to take action to protect the communications of all Europeans through the mass adoption of privacy-enhancing technologies. Thank you very much.
To Dr. Soghoian, thank you also for your evidence in Washington and for the work the ACLU is doing. And in relation to that, I wanted to ask you in particular if the ACLU has done a technical analysis or an analysis of the federal court judgment of the telephone data or metadata that was collected. Now, we had a congressional delegation led by Mike Rogers this week, and we had a very dismissive analysis of how effective that federal court judgment has been. But the reporting of it on the BBC and other outlets has suggested it's a significant judgment. Now, there's a 6-month appeal on this judgment, but some of the reporting, including on the BBC, has suggested that it could take effect immediately. Now, my question to you is, has the ACLU done an analysis of the judgment? And if it hasn't, are you going to do an analysis? Because we're also going to be talking to Glenn Greenwald later. Edward Snowden issued a statement via him and others indicating a welcoming of this judgment. Now, the reason I'm asking you this question is because the ACLU would be the key NGO that would analyse such a judgment, and we are quite interested to know that now that this is in the federal system, it's one of the key judgments being issued. There's a technical aspect to this. It's talking about telephone data, metadata. exactly how significant is it? Is it going to lead to other judgments? How far is it going to go? And it's important to us in the European Union to know exactly how much this will affect the domestic audience in the United States, given the reaction we had from this congressional delegation. My other question is the issue about the degree of cooperation between IT companies and the internet providers. We've had a lot of evidence from Facebook and all the other companies. You may have seen previous evidence that was given, and it was just to ask for a snapshot of your view of the evidence that you will have seen, because I know you're following the inquiry. I don't want a long statement, but just your thoughts on what Microsoft, Facebook, and the others were saying to us from an ACLU point of view. Thank you.
Thank you. Even if we have time, I'm going to ask colleagues. I mean, you get a different treatment because you're the rapporteur, but I'm going to ask colleagues to be a bit more concise, and also the panelists, so that we don't run out of time. Of course, you're privileged. Okay. Mr. Soghoian, you want to reply first?
I'll try and be as brief as possible. So I should be clear, I'm not a lawyer. I'm a computer scientist, and I'm embedded within a team of lawyers who do all of our litigation. We obviously disagree with Chairman Rogers. He's the chairman of the Intelligence Committee, and he's been a consistent defender of the surveillance program. We are suing the government to end the surveillance program, so we obviously have a pretty significant disagreement at the policy level. This case, the decision that came down this week, is the first. It's the first time that a judge on any court other than the secretive FISA court has actually analyzed this program, and for that reason alone, it is a pretty significant step. We have brought our own case, and other civil liberties groups such as the Electronic Frontier Foundation have also brought their own cases against the U.S. government, and so there are several federal cases running in parallel, all focused on this program. This really was the first case, the first decision by a judge, but we expect there to be others. The most significant aspect of this decision is that the judge sort of really tears apart the concept of people not having any reasonable expectation of privacy into their metadata, and in particular to the idea that if the government can collect metadata about one person, then it's okay for the government to get metadata about 300 million people who've done nothing wrong. So that's been interesting to see. This will not go into effect today or tomorrow. The judge has issued his opinion but stayed its enforcement until an appeal is processed. He has given the government fair warning, though, that once the appeal is decided, if it goes in the direction of privacy, that he expects the government to shut down the surveillance of the plaintiffs in that case straight away, and doesn't want any stonewalling by the government, saying that it would take a lot of time to actually remove their data from the database. So it's good news, and it's, if you haven't read the decision, although most judicial decisions are not particularly interesting, this one really is packed with some fun things. So it makes for pleasant reading if you're at all interested in surveillance. On the question of cooperation between tech companies, internet companies, and the U.S. government, I actually published an op-ed yesterday in the MIT Technology Review talking about how the Snowden disclosures had forced the technology companies to increase their security. I think it's important to note that the U.S. government will get data many ways. They will get it through their partnerships with international telecommunications companies, the companies that operate undersea fiber optic cables. They will get it through their partnerships with tech companies, and if they cannot get it in those ways, then they will hack into systems and steal it. They haven't really needed to go to Microsoft or to Facebook or to Yahoo and demand data at scale, because they could get it at the network level. Because these companies didn't encrypt their customers' information as it was transmitted over the internet, because they woefully were not securing their customers' data with the most basic of security technologies, the NSA could hoover it up, could collect it at scale at the points where it was transiting the internet. in the wake of the Snowden disclosures and in the wake of front-page news stories about this, Microsoft and Yahoo and several other companies have announced that they will be upgrading their security. And so I would expect that their relationship with the NSA will change, because now the U.S. government will have to go to them to get data that they didn't need to before. But you should remember that all of these companies have teams of people who are employed by them who do nothing but respond to surveillance requests. They know that they get requests by the U.S. government and by other governments, and they're comfortable with this as long as they don't get too many of them, and as long as each request isn't for too many people's information at once. Ultimately, many of these companies have embraced business models of advertising-supported services that give them an incentive to collect as much data about their customers as possible, which then means that the government, my government or other governments, can show up after the fact and demand this information. So there's not so much a conspiracy between the tech companies and the U.S. government to collect the data, and it's more a symbiotic relationship. The tech companies collect the data for their own advertising purposes, and then the government can show up later and ask for it.
Thank you. Mr. Horchet, you want to come in? No? Okay. Mr. Vos signaled that he doesn't want to ask a question, so then I put on my other hat again as a shadow rapporteur on behalf of ALDI. I have two short questions. First question to both of you. It's a bit, if you're being the devil's advocate, and I asked the question in the previous round, you spoke of the right to anonymous communication and even the right to anonymous financial transactions. And as a normal, innocent citizen, I agree with you that we should have that right and that we should be protected. However, there are criminals in this world. There are bad people. So how do we protect the good people but make sure that law enforcement authorities have access to information about bad people? Second question to Mr. Soghoian in particular. We heard from Mr. Rogers yesterday, the delegation from US Congress, the statement, there has been no mass surveillance. How do you qualify that statement?
So you will have undoubtedly been told that your countries are facing a grave cyber threat, that criminals and foreign governments are hacking into your systems and stealing sensitive intellectual property, stealing the data of your citizens. And that's probably true to a certain extent. But the problem is there's no way to design a system that is secure against the finest of nation-state hackers that your local police can also get into. You have to pick one or the other. Now, you have built networks and systems that have been designed for interception. Your national internet systems and your national internet networks and your national telephone networks have been built with surveillance in mind. Every single one of you live in a country where the telephone networks have purchased equipment required by law that have surveillance features built into them. Your global internet connections have surveillance features built into them. You shouldn't be surprised when someone else shows up and hacks into the system and enables the interception feature, which is exactly what happened to Greece in 2004 when an unknown entity broke into their network, enabled the wiretapping feature, and spied on the Greek Prime Minister and members of his cabinet. You have built networks that are insecure by design, and this is not an accident. This is this is the goal. And the reason is because your law enforcement and security services, their interests have come first. The question is, what are you more worried about? Are you worried about the threat of the US government and other governments spying on you? Are you worried about hackers and criminals stealing your information? Are you worried about the paparazzi listening to your telephone calls and stealing your information? Or do you want to live in a world where the police can easily get the data that they want? But you cannot have both. You have to pick one or the other. And I don't think that political leaders have quite woken up to this realization. I think many people think that they can have their cake and eat it too, that they can have European-made encryption technologies that will allow law enforcement access and keep Chinese hackers out. The NSA has the best hackers money can buy. And so if the police can get in, they'll hack into the police and use the police's credentials to get the data. If you want secure systems, you have to put security first, but that means giving up some forms of law enforcement access that traditionally would have been available. Now, that doesn't mean that law enforcement go dark completely, but it does mean that certain avenues of investigation and certain tools are going to slip into the history books. But, you cannot hide metadata. easily, and there's no way to hide location information. And this is information that was never available in decades past. There is now this wealth of location information that exists, revealing everywhere we go, and there is no way to hide location data. The laws of physics do not let you have a working telephone and have your location data not be available. So the police win some and they lose some, but right now you've built systems that are terribly insecure, and you're suffering the consequences of it. To your question about Chairman Rogers' statement that there is no mass surveillance program, clearly they're playing word games. They don't believe that a metadata program is surveillance. We respectfully disagree. I think we all know that the collection of information about 300 million innocent people in my country and countless hundreds of millions of people abroad, that is surveillance. Whether or not they look at it all the time, whether or not it contains the content of communications or metadata. Metadata is among the most sensitive information because it reveals intimate and private things. Your trip to an abortion clinic, your trip to a protest, that is captured in metadata, and so it's of course ridiculous to believe that this isn't surveillance.
Thank you. Mr. Albrecht for the Greens.
First of all, thank you to be here and to testify. I think those were very clear remarks. I mean, I also would like to ask about the interpretations which are out there that it's not like the media rights. That was something we heard yesterday. It's all different to what the media writes on these surveillance issues. So my question to you would be really, I mean, do you think that people are, or politicians are aware of what's actually going on and what's possible with the analysis of those personal data, metadata? And what would be your specific recommendations that we should draw the attention to in our conclusions here in the inquiry when it comes to security and to privacy protection and to the technical means which you are describing? Thanks.
So to the first question of are politicians aware of what's going on, I think the answer is probably no. You're starting to become aware, and this is in no way meant to disrespect politicians, but generally people who go into politics have a background in political science or the law. I mean, there are some exceptions, obviously, but many people in this room probably spent their university studies studying political science and not computer science. And so surveillance is really high tech. It's very complex, and I mean, even in my own country, the committees that are analyzing these issues, they don't have any technical people working for them. The FISA court, which is issuing these very creative opinions permitting surveillance, they don't have any technical experts working for them. And so there's in fact been this process that we've learned where the NSA has for years done things that the FISA court thought they weren't doing. There was a mismatch between the FISA court's understanding of what was happening and what was actually happening on the ground. And in many ways, that was because the information wasn't being communicated clearly by the Department of Justice and NSA, but also because the FISA court didn't know which questions to ask. I think it's difficult for lawyers and political scientists to perform effective oversight of highly complex technical surveillance programs when they don't have many or any technical experts working for them. And so in the longer term, I think, you need to think about how you equip yourselves with technical expertise. If your voters are not going to start voting in computer scientists, then you need to start hiring them at the committee level and MEP staff assistant level. To your second question of what should you be doing, as I suggested in my opening comments, I really feel like a lot of this comes down to a total regulatory failure. So the Europeans have what is probably the most robust system of data protection oversight of any set of countries. You have very powerful data protection regulators in some cases. and a willingness to regulate the telecommunications carriers. The massive reduction in roaming fees, for example, in Europe shows that your regulators are willing to crack the whip against the wireless carriers on issues that they believe to be important. The question is, why have your telecommunications and privacy regulators not cracked the whip? Why have they not pushed this issue of data security for cell phone networks? Similarly, in the last 2 or 3 years, Google, Facebook, Twitter, Microsoft have all finally upgraded their security to make passive interception at the network difficult, if not impossible. But this has largely been as a result of pressure by US government regulators, by civil society actors in the UK, in the US, and in other European countries. Where have European regulators been on the issue of HTTPS transport security? The lock icon in your browser, where has the pressure from European regulators been? The issue of cookies in Europe has been a major topic. The issue of Google Wi-Fi has been a major topic. And I think if European data protection regulators had spent as much time worrying about the lack of strong encryption in cell phone networks as they have done over cookies, I think you would find yourself in a very different situation vis-a-vis NSA surveillance of your telephone calls.
Thank you very much. It would be interesting to know if the situation would have been any different if data protection were still in the Department of the Internal Market rather than Justice and Home Affairs as it is now. I have 2 more speakers, Mr. Engström and Mr. Mulder, and then we'll wrap it up. Mr. Engström.
Thank you. Again, thank you for very interesting and very good presentations. And yeah, this is quite obviously quite a big problem. To Mr. Soghoian on the telephone thing, you talked about the encryption being completely broken since 2 decades. We have GSM and we got 4G. Is it the same problem, or is 4G in any way better, or does it apply to everything? And then you talked about that, and you talked about the lawful intercept capabilities that are part of it. Am I right in thinking that these are 2 separate vulnerabilities, and if so, which one is the more serious one? And to Mr. Horchert, continuing on Ms. Intveld's playing the devil's advocate, when it comes to anonymous communication, I would say that's politically doable. We got to Article 8 in the European Convention, the right to private communication. So okay, that's probably doable. When you talk about the need for anonymous payments, that will, if anybody puts forward a proposal like that, other people will say, okay, that's gonna facilitate money laundering on a massive scale. Now, how would you respond to that person? How would you respond to that counter-argument?
Okay, last question, Mr. Mulder.
Thank you. I equally find it an extremely fascinating discussion, and to continue the analogy with a house that you lock and so on. You will never have a system that is completely safe. Whatever you do in a house or in a safe, there will always be somebody who is able to be more clever than the protection. But if you have a reasonably protected house, is it possible for an individual to buy the technology today on my phone or on my laptop or whatever it is to have it reasonably protected? You have the commercial companies that sell it to you, and apparently that's not sufficient, but is it possible that it will be the case in the future? Or secondly, is it only a case of the regulators, European or national, that can assure that protection?
The first few questions from Mr. Engström, you asked first whether this was an issue that affected older phones or whether the 3G and 4G networks were more secure. I'm not going to bore you with the intimate details, the intimate technical details, but what I will say is that the security of the 2G networks are 30 years old. And the problem is that the latest and greatest cell phone that you can buy in the stores today, the latest iPhone or latest Android phone, although it will use 3G and 4G when available, will still include the feature, the capability of 2G, so that in case you go and visit a rural place or you visit a foreign country where only 2G is available, it will work. And so one of the techniques that foreign governments use, or what the governments use when doing interception, is they jam 3G and 4G, and then they offer their own 2G network that is their own, and then that forces your phone to connect. That is one of the problems. There is better encryption in 3G and 4G, but the carriers must use it. They must choose to use it. Just in the last couple of weeks, T-Mobile in Germany revealed that they were moving their entire network to the latest generation of cell phone encryption for voice communications. But this encryption technology was actually created in 2002. And so it's taken a little while for it to see mass adoption. I mean, 11 years for it to see mass adoption. The cell phone networks move really, really slowly. And so long after cellular encryption technologies have been broken, consumers still continue to use them because the networks continue to keep them deployed. Your second question was whether the vulnerabilities I described in the law enforcement interception features in networks was the same as the one of mobile phone tapping that I described in my opening remarks. No, they're separate issues. To be able to exploit the law enforcement surveillance interfaces built into the networks, you have to have access to the inside of the networks, to the core of the networks. Obviously, you could do that if you are a government, or if you are the government in that country, or if you employ sophisticated attackers, which many governments do. So that doesn't actually create a practical barrier. On the other hand, the mobile phone, telephone vulnerabilities that I described in my 10-minute opening remarks, those can be exploited by everyone right now. Anyone who's within, a mile or two of you can listen to your calls if they have the right equipment and have the desire to do so. And so this isn't just an issue of governments. This is something that the paparazzi can do. This is something that companies can do against their competitors. In India, there has been widespread illegal importation and use of cell phone interception equipment that has led to a dystopian future where anyone's phone call can be intercepted by anyone else. And you see the phone calls of members of parliament in India being leaked to the press, of billionaires talking on the phones to their lovers also being leaked to the press. I mean, it's truly chaotic, and people there have totally given up any faith in the security of the phone networks. The next question was this idea of, can a house be kept completely safe? Well, to go with your analogy, no one's even tried to put a lock on the door right now. The door has been open for years, and the only thing stopping people from listening to our calls has been that no one was trying, or in fact, the people who were doing it weren't talking about it. This isn't a question of whether we have next generation cutting edge security or sort of okay security. For years, you've had no security at all. And so let's get to a point where we have reasonable security, and then we can talk about whether it's good enough. But right now, you have nothing. And was there a second question after that? I think that was everything. Sorry. Is that a question of regulators, or is that a question of an individual? So there exist tools right now that anyone can download that let them make secure encrypted telephone calls. The problem is, as the expression goes, it takes two to tango. And so both parties of the call need to use the same tools. There are apps that I have on my phone right now that I use to make encrypted calls, but the number of people who know about them and who've downloaded them is very small. So I'm professionally very paranoid, and many of my colleagues are very paranoid, so we can have encrypted telephone calls, and I can send encrypted text messages to my girlfriend. But that's about it. If we want to see the mass adoption, and if we want these to be the default, tomorrow, if you buy a cell phone, if you want it to come pre-installed with encrypted voice, encrypted text, encrypted email, either you need a market solution, you need companies to offer this, but given the lack of competition in most cellular markets, that's probably not going to happen. Or you need regulators demanding it. And so if your national regulators tomorrow said it is not possible, it is not going to be allowed to sell a cell phone that does not include encrypted voice enabled by default, then that solves the problem. But right now, it requires action on the part of users, and we know that anything that requires action will actually mean that it will not be widely deployed.